Welcome. In this video, we will discuss about the Joint Parliamentary Committee on Office of Profit. So UPSC has asked about the definition of Office of Profit in its prelims examination of 2019, and in general from your polity perspective it is important to know what is Office of Profit all about, what are the constitutional provisions for it, what has been the law evolved over a period of time, and is there any definition to define what exactly accounts for Office of Profit. So we will discuss about all this in this particular video. So let's begin. The first thing we need to know is the article which actually deals with the conditions of Office of Profit. So this is Article 102 Clause 1, which talk about a person shall be disqualified for being chosen as or for being a member of either House of Parliament. So in case of Parliament or in for the MPs, the rules or the article which talks about the clauses is actually Article 102. So it talks about Parliament or members of Parliament. So what are the disqualification criteria? So these are if he holds any office of profit under the government of India or the government of any state other than an office declared by Parliament by law not to disqualify its holder. So until specifically the Parliament has passed a law under which that particular post has been delisted. Apart from that, if he is holding any office in the government, central government or state government, he will be disqualified for holding the office of profit. Then what are the other criteria? If he is of unsound mind and is deemed to declare by the competent court, if he is undischarged insolvent, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance or adherence to a foreign state, then if he is so disqualified by under any law by parliamentary explanation, for the purposes of this clause, a person shall not be deemed to hold an office of profit under the government of India or the government of any state by reason only that he is a minister either for the union or for such a state. So because he has acquired some post of minister, so this office of profit is also extended to the minister. He should not be getting into any post in the central government or even in the state government. So these are the disqualification criteria which is mentioned under the Article 102, that if he is having any of these things, he would be disqualified from being a member of Parliament. Similar thing is mentioned in Article 191 Clause 1, but it deals with the members of Legislative Assembly. So instead of wherever you are seeing Parliament, it will be Legislative Assembly, and instead of member of Parliament, Article 191 deals with member of Legislative Assembly. So again, both of these for legislative assemblies, state legislative assemblies as well as parliament, there is a provision that if a person is a member of parliament or member of legislative assembly, he should not be holding the office of profit. Otherwise, it will be accounted for his criteria for disqualification. Now let's try to understand what is basically this office of profit is all about. So MPs and MLAs as member of the legislature hold the government accountable for its work. So this is what is the thing. We know that the cabinet minister, the executive or the council of minister, they are responsible for the Lok Sabha in case of the parliament and for the state legislative assembly at the state level. So these are responsible, they make them accountable for their work. The essence of disqualification under the office of profit of law is if legislator hold an office of profit under the government, they might be susceptible to government influence and may not discharge their constitutional mandate fairly. Think about it, if an MP who is supposed to make the government accountable for what kind of work it is doing is employed by the government or it's taking some kind of gain or benefit from it, they could be more susceptible or vulnerable to take side of government, or in just case they will not be unbiased in their decision and hence they will not be able to perform their constitutional duty. So this is the concept why office of profit was included. The intent is that there should be no conflict between the duties and interest of an elected member. So an elected member duty is to hold the government accountable for its work, and it might be if he is holding the office of prophet, his interest could lies elsewhere. In that regard, a conflict could occur. In order to avoid such kind of scenario, office of prophet was introduced. Hence, an office of prophet law simply seeks to enforce a basic feature of the constitution, which is the principle of separation of power between the legislature and the executive. So, if you know, the Indian polity talks about the separation of power under Article 50, in which there is a separation of power between judiciary and legislature, between legislature and executive. Though, unlike the other model in India, there is a partial separation of power between legislature and executive, because executive is responsible to the legislature. Go back to your Lakshmikant book and revise that particular topic. Now let's move forward and try to understand what is the definition. So the first of all, the thing that you need to remember is that the law does not clearly define what constitute an office of prophet. So there is no clear definition for office of prophet, but the definition has evolved over the years with interpretation made in various court judgments. So court judgments has keep on coming regarding what could be considered as office of prophet. So from that regard, an inference could be made. But just remember, the definition itself is not clearly defined. An office of prophet has been interpreted to be a position that brings to the office holder some financial gain or advantage or benefit. So this is something how the office of prophet has been generally considered, that if that particular office holder is gaining any capital gain, any financial gain, then it could be a office of prophet, or any benefit or advantage, then also it could be an office of prophet. The amount of such profit is immaterial, so it's not like he has to make only that much capital gain, then only that will be considered as an office of profit. That particular concept is immaterial. Even if he is getting like 100 rupees from a post, doesn't matter, that could still be considered as an office of profit. In 1964 itself, the Supreme Court ruled that the test for determining whether a person holds an office of profit is the test of appointment. So basically these are the few things that Supreme Court has highlighted way back in 1964 itself, that whether the government is the appointing authority, like for any post under which it is being questioned that whether that post is under office of profit or not, the question is whether the government is the appointing authority, or whether the government has the power to terminate the appointment, whether the government determines the remuneration, what is the source of remuneration, and what is the power that comes with the position. So these are the few criteria which in 1964 itself Supreme Court said that if it is the government which is appointing that particular post, it is the government which has the power to terminate it. Also, if it is the one which is determining what kind of remuneration will go for it, what is the source of that particular remuneration, and also what is the exact power which will be provided once that person is in that position. So these are the few criteria which Supreme Court highlighted, which could make it easier for the courts to figure out whether a particular office could be considered as an office of profit or not. So this is what the Supreme Court ruled in 1964. Now, what is the protection against the disqualification? So, as mentioned in the Article 102 and even 100 Article 191, it is like if the Parliament law has specifically defined some post to be away from the list of office of profit, then these office or these particular posts will be protected against the disqualification. So provision of Article 102 and Article 199 also protect a legislator occupying a government position if the office in question has been made immune to disqualification by law. In the recent past, several state legislatures have enacted laws exempting certain offices from the purview of office of profit. So this has already been done. In fact, the Parliament has also enacted the Parliament Prevention of Disqualification Act in 1959, which has been amended several times to expand the exempted list. So in the exempted list will be the list of the post. If like that particular post is provided to the member of parliament, they will not be disqualified under Article 102. There is no bar on how many offices can be exempted from the purview of the law. This raises an important concern. If a large number of legislators are appointed to such offices, their role in scrutinizing the work of the government may be impaired. Think about it. The list under which the offices could be exempted could be unlimited. In like all probability, it is very feasible or very possible lawfully that they could exempt all the offices. So in that regard, again, the whole criteria or the whole intent because of which the office of profit is made is kind of done away with. So that is the major concern which is highlighted. Now let's also try to understand that what is the debate regarding the parliamentary secretary. So it is like the appointment to the office of parliamentary secretary. Could it be considered as a office of profit or not? So interestingly, the appointment of legislators as parliamentary secretaries, in spite of the office being exempted from the purview of the Office of Profit Law, has been struck by the courts in several states. So this is something very interesting, that even though the parliamentary secretaries, these are in exempted list of what is considered under the disqualification. But even then, the court has struck down their appointment in several states. So, a Calcutta High Court judgment in 2015 held that since the position may confer the rank of a junior minister to a legislature, the appointment of MLA as parliamentary secretaries was an attempt by state government to bypass the constitutional ceiling on the number of ministry. So think about it, we have a provision under the Article 164 which says that the number of ministers including the chief minister should not exceed 15% of the total members of the assembly. So it cannot be more than 15% of the assembly. This was specifically added after the Constitutional Amendment Act of 91st Constitutional Amendment Act, because what happened to, in order to gain the political mileage, in order to please the other party, and the coalition government was into picture in that particular era, the idea was that more and more people were getting, any new department was being formed, new kind of ministry was being formed to provide them the post of cabinet minister. The idea was that this 15% will actually stop that kind of thing, because in order to create a ministry, in order to have a minister, the whole remuneration, the infrastructure, the supporting staff, all of this actually require a lot of effort, and it was not very feasible. So for that purpose, after 91st Amendment Act, the ceiling was put that it will be 15%. But now what the court, and why the court has struck down the parliament secretary's appointment as office of profit, even though they are exempted from the office of profit disqualification, is because it could be considered as the state trying to circumvent the constitutional ceiling, that in order to please a particular member, they are appointing them as parliamentary secretary, which is actually almost as a status of cabinet minister. This was highlighted in 2009 when Bombay High Court also held that appointing parliamentary secretaries of the rank and status of cabinet minister is violation of Article 164A of the Constitution. So this is again was highlighted in 2009, and in 2015 again the Calcutta High Court said the same thing. So this is the controversy or the debate regarding whether the parliament secretaries, the post could be like up for disqualification. These are the few things that you need to know. So from your polity point of view, you need to know what is office of profit, whether that is defined in the constitution, which articles deal with it, what are the criteria because of which the any office could be considered as office of profit, what is the debate regarding the parliamentary secretaries. These are the things you need to pick up. So I hope you have understood this video. If you have any doubt, feel free to drop a comment. Thank you.